Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, I will discuss with you the psychology of a false dowry case. So, whenever you and your parents are entirely indulged in a false dowry case, it might be under section 498A of IPC, might be as per section 85 of BNS, it might be as per section 406 of IPC or section 316 of BNS. It might be as per section 34 of IPC or as per section 3 subclause 5 of BNS. It might be as per section 3 upon 4 of DP Act. So whenever there is a case against you and your family, all of you got panic because you think that whenever you will visit to the concerned PS, the concerned authority might arrest you. There is no need to be in a panic or in anxiety. We have to understand the legal provisions, the legal position more specifically laid down by the Honorable Supreme Court. Honorable Supreme Court, in its one of the most important judgment, titled as Arnesh Kumar versus State of Bihar. Judgment date is 2nd of July 2014, specified that in any offence, I am going to emphasize on the word any offence, if the imprisonment is up to 7 years. In that scenario, the concerned accused could not be arrested. The concerned official of police is entirely bound to serve a notice as per section 41A of CRPC. If there is no notice, an arrest is going to be effected in the mechanical way, the concerned erring officer would be responsible. And apart from that, it is specified that the concerned magistrate is also duty bound to check out whether the concerned mandate is entirely followed by the concerned official of police or not. If it is not, in that scenario, the magistrate could refuse the remand and could restore the liberty of the concerned accused. So simply we could say that in matters concerning with dowry harassment, no automatic arrest is appreciated even by Honorable Supreme Court of India. So if the arrest is going to be done in the mechanical way, the erring officer would be responsible towards the departmental action. So basically we have to understand that the arrest could not be done because concerning the offences, the maximum term of imprisonment is up to 7 years. So we could have the benefit of Honorable Supreme Court verdict, that is Arnesh versus State of Bihar. So I think that right now you are not in the state of panic because we entirely understand the conceptual perspective that no arrest could be done, more specifically in the matters concerned with dowry harassment, because the imprisonment is less than 7 years. Now the important question arises how to proceed if we are going to charge sheet it, whether we could go for a discharge or for quashing. So concerning this, we have to understand the guidelines propounded by Honorable Calcutta High Court, that is pronounced on 26th of Feb 2026. In that case, the concerned husband and his parents had been prosecuted as per section 498A, section 406, section 34 of IPC along with section 3 upon 4 of DP Act. Facts are quite simple. It is submitted by the complainant that she has been married, a child was born, but she has been subjected towards dowry harassment. Finally, she lost a FIR and the accused persons were charge sheeted. The accused persons had submitted a discharge petition, but the same has been rejected by the concerned trial court. Finally, they availed the further remedies. It is submitted by the petitioners that the marriage has been solemnized without any demand of dowry. At any spur of moment, there is no demand of dowry. It is submitted that the marriage has been survived for a long time, and during this period, there is no complaint by the concerned wife. So, it is indication of the fact that the present complaint is afterthought. It is totally malicious and inter alia, it is submitted so that pressure could be mounted and the concerned petitioners could be easily extorted. In addition to this, the contentions are that there is no specifications about demand of dowry. If the allegations are non-specific, uncertain, unclear, in that scenario, the same could not be the basis for the prosecution or proceedings as per the protocol of dowry harassment litigation. In addition to this, it is specified that no specific role has been attributed to the concerned petitioners. The concerned petitioners, I am going to emphasize on the mother in law and father in law, submitted that it has become the daily grind of the woman to lodge the FIR against the in laws. Such practice is liable to be discarded as observed by Honorable Supreme Court in case of Preeti Gupta versus State of Jharkhand. Citation is 2010, Volume 7, SCC, page number 667. So, if the allegations are not specific, no conclusion could be drawn. And in addition to this, it is submitted that there is no specification in the charge sheet in which manner the crime has been committed, what are the specification, and what is the specific role of the concerned mother-in-law and father-in-law. So the court observed that if the marriage has been survived for a long term, during that period there is no complaint. Apart from that, the allegations are general. And apart from that, no specific conclusions could be drawn regarding the allegation. In that scenario, the proceedings are abuse of process and liable to be discarded. So in that case, the proceedings had been quashed and set aside by Honorable High Court up to the extent of mother-in-law and father-in-law. So whenever we are facing a false dowry harassment case, we could follow three important steps. Number one, submit your memorandum in which you are supposed to give the plausible explanation of all the allegations. If you are doing this practice and inter alia it is not considered by the concerned IO, you could chalk out a case for the unfair investigation. In addition to this, while submitting the memorandum, just buttress your argument with the help of specific evidences, but remember that the evidences must not be inconsistent, it must be corroborative, and apart from that, you may also rely on judgment of Honorable Supreme Court and High Court. In case the authority is not going to show any willingness to follow the legal position and they are going to do the investigation as per their own whims, we could have the benefit. Point number three, do not be in the anxiety to move for questioning. First of all, ascertain the allegations quality. If the allegations are non-specific, just wait for filing of charge sheet. In case the concerned persons are dropped, we are having the benefit, but despite a memorandum, still we are charge sheeted and police is not going to consider our case, then we could move for discharge. And if discharge petition is rejected, then we could move for the questioning. Because in questioning, we have to show the abuse of process. We have to show the continuance of proceeding is totally unjustified. But in discharge, we have to show that the charges are groundless. So simply we could chalk out a case for unfair investigation also. So in that way, the chance to get success would be on dominant side. Rather we go for a questioning and inter alia, if questioning is rejected, we have to move before Honorable Supreme Court. So basically, to avoid all such panics, do not be in the anxiety. Just submit your memorandum. In case it is not considered, you are charge sheeted, then we could file a discharge and then we could proceed before the Court of Revision. And again, it is not going to be considered, then we could file a petition before Honorable High Court as per section 528 of BNSS. So I specify you how to proceed whenever you are having a false dowry case against you, so that you could easily encounter the allegations and could specify your stand before the concerned court. See you in the next video. Till then, Jai Hind, Jai Bharat.